Welcome, happy Friday. Welcome to our weekly privacy chat. We've been pretty good about doing it weekly, but frankly, we've had no choice. There's just been so much dramatic news in the global data protection world that even when we want to take a break, we've got to get back to it to stay on top of what is going on. I'm joined by two very special guests. I'll introduce Rob Van Eijk, who many of you know, our European director, who can introduce our good friend Tobias from the Norwegian Data Protection Authority. Rob.
So welcome all. It's great to be on the show today. And with us, we have Tobias Judin. He's the head of the Norwegian Data Protection Authority's International Department. I'm super happy to have you with us today to help us unpack all the complexities that we've seen around this topic.
Thanks for having me.
Welcome, Tobias. All right, let's jump right in. And by the way, we're watching the comments. So if you wonder whether or not behavioral advertising was just banned in Europe, banned in Norway, banned in any place Norwegians can navigate to, ask us and we'll jump in and make sure we address some of your comments. But let's start with the biggest question. Why are we talking about this and Norway? Are Norwegian citizens uniquely vulnerable? Don't we have a one-stop shop? Help us understand the process. We had an ECJ case. We had Ireland taking action, but going through their process, which obviously can take time and has legal constraints. The EDPB. Help people unpack for those who are not, watching every single step, how this got here, and is the one-stop shop over? Because, of course, DPAs can, under emergency bases, take action. Was this an emergency? What do you say, Tobias?
I think that's a great question. And, I would argue that actually right now we are applying the one-stop shop, but we're applying a different part of it that hasn't really been utilized any up until now. But we are still very much within the one-stop shop. So essentially, some people might recall that in December of last year, the Irish Data Protection Commission, which is then the lead supervisory authority for Meta, they issued decisions stating that, well, actually, Meta has been processing personal data unlawfully for behavioral advertising because Meta based that on contractual necessity. And following an EDPB process, the Data Protection Commission of Ireland said, no, you cannot do that, and please start complying with Article 6.1. Please find a valid, lawful basis for your activities. So far, so good. And then Meta was given until I think it was 5th of April to comply with this order, to find a lawful basis. And as part of that, we all received compliance material, reports, etc. And when we assessed those compliance reports, we quickly discovered that, well, actually, Meta hasn't complied. Meta is still processing personal data unlawfully. There is still an issue here. So Meta did switch most of its behavioral advertising to legitimate interest. But in our view and in the view of the other regulators, they didn't fulfill all the requirements. So then we said, hey, Meta is still processing personal data unlawfully. They have essentially not complied with the orders that were issued in Ireland. And this is a serious case. I mean, massive amounts of data, very intrusive monitoring, profiling, and it's going on continuously. And it seems that, decision from the regulators is just being ignored. So from our point of view, this was an urgent situation. And the GDPR actually states that if there is urgency, any of the European data protection authorities can actually make a decision on their own territory, but with a caveat that it can only be valid for up to 3 months. So that is what we did. We said, hey, this is urgent. You're not complying with the orders. This really needs to stop now. It's been going on for a long time. And then furthermore, what we can do in order to ensure consistency across Europe is then to actually take the matter to the EDPB and ask for a permanent ban of EU and EEA-wide application. So that way, there would be no permanent derogation from the one-stop shop. You would get everything to the EDPB, where you have all the European data protection authorities, and then you can find a harmonized approach to this. And that is essentially what now happened. Last Friday, the EDPB decided that our ban should be made permanent and should apply across the EEA. And the precise scope is then a ban on Meta's processing for behavioral advertising based on contracts and based on legitimate interest.
Interesting indeed. I do confess that when the GDPR was being negotiated and the one-stop shop was being discussed, I definitely imagined the sort of emergency procedure and so forth to be sort of, well, there's some giant data breach and it's ongoing, and people are being affected in one country, and the other one that actually has sort of lead authority isn't reacting, or so on and so forth. I recall 25 years ago as a chief privacy officer, rolling out behavioral advertising. Much, of course, the Meta stuff is at very large scale and so forth. But some of this is happening today and has been happening for many, many years. And so in some sense, the urgency has sort of been about the speed of the process, right? I mean, it's possible that the Irish regulator will come to the same conclusion, but in their sort of due course. That does, and there may be other jurisdictions perhaps that are also, have slow procedural or disagree on some subject matter. Now that the tide has been opened, do you imagine the sort of emergency procedure will be something that's used, regularly, or maybe it's just the big platforms because they have so much data, so whenever they act, it's high risk, or do you think this is sort of a one-time emergency situation that has unique gravity?
Yeah, I would say that this is a bit of a unique situation, because we're now, normally you go through a one-stop shop procedure where you have the lead supervisory authority, you have a draft decision, maybe you have an EDPB process. One thing that's unique here is that we already finished all of that, and the controller is still not complying with the decision. So that's one unique element. Another unique element is that we actually try to go through, let's say, the normal mechanisms beforehand, before we issued our decision. We tried to ensure that enforcement was going on in the country of the lead supervisory authority and in the controller's main establishment, but there was no enforcement essentially. So that is also a reason why we had to act urgently, but certainly we did try. And while the EDPB's binding decision is not yet public, it will be made public pretty soon, I would imagine. The EDPB actually will confirm in that the urgency mechanism is reserved for exceptional circumstances. It's not the normal rule. So I don't actually envisage this being used a lot moving forward.
So our big conclusion, and then Rob, I want you to weigh in on this as well. During the cross-border and Schrems sort of process and so forth, Meta was also sort of the big test case and the focus. And many other controllers said, well, that's about Meta, and we'll continue transferring data, even though it's not clear exactly our basis for doing so, because we don't have a good solution, and we're hoping there'll be a privacy shield or a update to the process. And that, of course, didn't make sense, right? The conclusion that because of the US surveillance environment, one couldn't transfer data, certainly at least without the protections that were eventually agreed to. It seemed like people didn't want to generalize the legal understanding because they didn't have a good answer. And so I expect that people here are looking as well, and they're saying, since clearly behavioral advertising is happening as we speak, billions of points of data as we breathe are being traded and shared and tracked and targeted and so forth. And the question is, as people look at this decision, should they all take the conclusion that legitimate interest, since presumably what many are relying on for some forms of targeted advertising? I'm avoiding behavioral because I think that's the big definition. So is legitimate interest dead? Did the German competition authority and the ECG really bar this for all first-party behavioral advertising? there was a lot of discussion of sort of the third-party scope of Meta in some of these decisions. Was it that the right to opt out, the Norwegian decision criticizes the balancing test, and that the opt out didn't work as a right to object should have. Facebook maybe has uses a very wide scope of data, and in the decision itself you point out that no, this is not a ban on all targeted advertising, and there's a specific definition of what is clearly to be allowed. So that's a sort of a huge question with a lot of pieces, but I'll let you sort of inform us. Is legitimate interest dead? Is a narrower scope maybe warranted, because you can make a fair argument about the balancing tests? What's the impact of third-party data? EDPB didn't seem to be concerned about third-party data when they offered their opinion previously on the risks of using legitimate interest. What do you think? I'll ask Tobias, and then Rob, let me know what you think as well.
I think this is an excellent point. And from our point of view, legitimate interest is not dead. So it's always going to be a case-by-case assessment in terms of what will the individual reasonably be expecting, what can they reasonably expect, but also looking at specifically in this particular case, how much data you're collecting, for how long are the data stored, how are they being processed, how intrusive, etc., etc. So in our decision, we looked very specifically at what is Meta doing, and specifically at behavioral advertising. By that, we actually we try to define that. Behavioral advertising is when you observe someone's behavior and use that to target ads. So, observing behavior, that could be, how fast does the person scroll past content? What does the person click? What's their location? Which ads do they click? Which ads do they not click? Who are they talking to? What are they writing? Etc., etc. So we only look specifically at that. And I would argue that targeted advertising or personalized advertising is actually much wider than just behavioral advertising, because you could still have contextualized advertising. You could have, advertising based on interests that are declared by the user actively. You could have advertising based on the profile bio information of the user. All of those things would actually be outside of scope of this order because it's not behavioral. So we certainly haven't ruled anything out there, I would say. So I think it's important to not, get ahead of ourselves and just say that, all targeted advertising needs to have consent to be valid. That is not the case. And, this would be a bit of a hypothetical, but if Meta had come back to us and said, yeah, valid point, we can't base this on 61F. So this is, these are the things we can do to limit the collection. These are the things we could do in order to limit the scope of processing. If they had done that, in a very significant, on substance, if they actually proposed something of substance there, then I think we would probably be open to reassess it. So it's certainly not a blanket ban. It's not a blanket ban on targeted advertising, not necessarily a blanket ban on behavioral advertising either. But for this specific use case, behavioral advertising for Meta would then be banned on the legal basis on which they have relied until now, I would say. I don't know if you see this the same way, Rob.
Yeah, it's super complex because we're dealing with advertising in the context of a social media platform. Some businesses have a presence on there as well. We have the specific court cases on joint controllership. So the type of advertisement where a platform user already has an existing relation with, for instance, they have already engaged with one of the brands that's on Meta, on Facebook, may trigger already a type of advertising that could fall within the scope of 6F. Obviously, the balancing test is the third step, is the most important one, and this is where the weight of the observed data and the inferred data comes in, of course, and it matters whether a user chose to disclose information about him or her on the platform with a reasonable expectation of that data also be used within that first-party relationship. I also want to point out that I always try to simplify the types of advertisement in contextual targeting and retargeting, where the retargeting, of course, has a much higher impact on the rights and freedoms of the individual. Putting that within the context of a social media platform adds to the complexity, of course. So I do agree that, and maybe it's interesting to point to the Dutch case that has been referred to the European Court of Justice. It's the Royal Dutch Lawn Tennis Association, case C621/22, which deals with the question, can you actually invoke the legitimate interest legal grounds of 61F for a pure commercial reason or not? And the Dutch DPA has taken a very specific stance on this. And obviously, it's going to be a more lengthy process to get a specific ruling of the ECJ on this. But that's going to be an important landmark ruling to keep an eye on, I think. And of course, guidance is still being prepared by the EDPB on the legitimate interest legal ground. Anything you could share on that process, it would be super helpful. But I think most of the cases dealt with in that guidance that's being prepared is going to be super complex with the recent developments.
Good.
Yeah, no, I think you make a very valid point that indeed the EDPB is preparing guidelines on that, and my authority is also very much involved in assisting in the creation of those guidelines. Just one thing, coming back to what Jules said about first-party data versus third-party data, because what we have been looking at in this particular case is actually first-party data. We haven't really assessed third-party data collection simply because Meta purportedly relies on consent for that. So it was technically outside of scope of our inquiry, therefore also outside of scope of the EDPB inquiry. But I think this is interesting if you look at the Bundeskartellamt judgment from the CJEU, which actually looks at both first-party data on Meta, but then cross-use of first-party data, and then third-party data from third-party websites. So it's a bit of a complex landscape, I'd just like to add.
Juliana Aruva says, how do we reconcile the direct marketing terms in GDPR, recitals 47 and 70, which seem to allow profiling on legitimate interests? And the DSA, recital 68, which says that GDPR requires consent. So the DSA is interpreting the GDPR for us. How about that? Requires consent for the use of personal data for targeted advertising. But of course, everything in the DSA is subject to the GDPR, which then is interpreted by the DPAs, not the drafters of the DSA. What is the difference between profiling? Okay, I'm going to leave that for a second because I don't know that we want to take the opinions of the commission drafters of the DSA, which are subject to what the DPA say the GDPR means, for some opinion that someone stuck into that recital where they wanted to maintain this point. All right, maybe we'll come back to it if we have time. But here, let me ask you this. I always like to think of whenever the word context comes up, and Rob and I debate all the time, the contextual advertising and so forth. Whenever context comes up, I think of the news media. I'm following very closely, as many of you know. I've got friends and family in Israel. We have staff in Israel. I'm following the news. It's the cover of the New York Times, the Washington Post, probably many major media around the world. Hamas, Israel, genocide, violence, so on and so forth. I suppose the people selling tanks and bullets, or I don't know who wants, but clearly there's not a context for most advertisers, to be there. And clearly some major media do not have registration information, right? And in some ideal world, maybe we don't want everybody having to register. And certainly there are visitors who don't register. Most of the news media rely in those cases on behavioral ads of some sort, a lot of times third-party information, but also, well, this person was at the auto section or the sports section. So even though they're reading about, Gaza, they're going to get an ad about their favorite sports team or so forth. The definition of behavioral advertising, and I commend it to folks, it's on page 3 of the data SILNet, the Norwegian Data Protection Authority's decision. Targeting ads based on inferences drawn from observed behavior, as well as the basis of the subject's movements, estimated location. I assumed that meant precise location, because the decision did say, for instance, you could target an ad that somebody's in Oslo, but I guess estimated location, that probably meant like very precise location, and how data subjects interact with ads and user-generated content. So, are the news media in Europe to stop their behavioral advertising? They're not social networks, so maybe they don't have the highest risk data, but they certainly may have a profile of a users surfing throughout that site. They're a returning user. I don't know, maybe they're targeting more precisely than Oslo. They're targeting, by, oh, this is a student because they're coming in from like a major university set of, IP addresses in this corner of Oslo. Thoughts on that?
Yeah, interesting. I don't know if you saw, but there was a case in Sweden actually pertaining to this particular point. So you had a news company called Bonnier Media in Sweden, which indeed does provide behavioral advertising to readers of newspapers, and this is based on 6.1f. And then the Swedish Data Protection Authority said, no, you can't do this, because in this particular case, the individual's rights and freedoms and interests outweigh your commercial legitimate interest. So they were actually barred from continuing doing that. I think they even received a fine. We have the same situation in Norway where media rely on this basis for that particular form of advertising. I would still argue, though, that it would be a case-by-case basis. So it would really depend on how much data, how broad are the categories. If they, through observing my behavior, can see that I'm not interested in news articles about sports and cars, but I am interested in news articles about politics and tech, I perhaps that's lawful. I don't really think that in itself would be an issue. But once you start, with more and more granular profiles, once you start really monitoring what I'm doing in a more detailed manner, that's when you get the issues. So I don't think there are any clear answers here. There are certainly many gray areas, but at some point, if the monitoring and surveillance is too detailed and intrusive, and the profiles are, borderline creepy, which, with respect, we think they are on meta platforms, then you're going to have an issue, I think. So there's a big difference between, interested in news about cars and, as we've seen on Meta, pride, gay love, high anxiety, therapy. Huge difference.
Rob, I want to answer and raise Steph Elliott's question, but then also ask you for your thoughts on, how does one fix what has become a system that clearly is troubling to regulators and consumers and folks sort of around the world, without, crushing perhaps legitimate business models where some degree of data is valuable for reaching users with efficient offers and supporting an economic environment that supports news media in a proportional way, in a necessary way, perhaps even with whatever the limits that need to exist around that are. But Steph Elliott says, and he calls me out on, show me where in GDPR we have this first-party data and third-party data distinction. It's a lazy term. And he's right. And frankly, usually I'm jumping on people when I say, because in industry that this is a huge distinction, that is made, and the assumption is third party bad, first party good, and first party you can do whatever you want. And of course, regulators have always said no. The reason we're worried about, let me not say third party, but the uncontrolled sharing without any way of providing any guarantees of consent being carried along, or the user's expectation that hundreds and hundreds of companies, blah, 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 blah. So a lazy term, but I guess what is clear is that if the data is shared with an unnamed number of parties, if it's bidded and traded and sold, clearly, as we see from the Belgian regulators' sort of debates around the TCF and so forth, hard, maybe possible, maybe not, but a high risk situation where real serious controls need to be in place, the Keneal Criteo sort of guidance as well. How do you actually, prove that you're guaranteeing the user's rights throughout the cycle? So true, maybe let's not make the hard first and third party distinction. However, let's recognize that is going to be the hardest set of areas to argue that you've got a legitimate interest base around because of the particular risks of data going to multiple parties. You've got an easier argument that the user has some sense that they're interacting with a service as opposed to hundreds of other companies. So you've got a better case that maybe there's a balancing test that could be worked out if you don't bid and sell data in an uncontrolled way. So Steph's right, but I think there actually is an important lesson to learn from the measures that might be put in place. So Rob, in addition to don't sell the data to 1,000 parties, Tobias gave us some parameters, retention, sensitive data. What are some of the other proposals we're seeing from startups and technologists, sandboxes maybe even, I don't know, right? Where do you see the remedies that might constrain a system that is creating such legal pushback, but that balance some of the utility that might be valuable, important perhaps for competition as well? Interesting that a competition case is what created this all, because you often hear industry arguing, oh, the reason data needs to be sold and traded and so forth is we've got to compete with the biggest companies. The regulators have said no, they don't get to do everything. We'll turn to that, and now we're seeing them turning to that. But tell us what you think, Rob.
Yes, so most of this relates, of course, to the real-time bidding ecosystem that's off-platform, so outside of Meta. But unpacking it, I mean, the balancing test obviously will weigh the impact on the rights and freedoms for the individual. And for instance, taking into account a data point like hyper-precise location may tip that balance not in favor of the data controller to invoke this legal ground. So lawfulness ultimately within the advertising context boils down to two key risks from where I'm sitting, which is the sharing of data and the secondary use of data. Specifically for the secondary use, it's important to keep in mind, if you want to reuse data, can you then actually rely on the initial legal ground when the data was collected? And so that's actually quite an important question if you want to propagate that consent throughout the value chain. But more importantly, consent needs to be able, user needs to be able to revoke his or her consent at any moment in time. And this is why, for instance, in the transparency and consent framework of the IAB, we now see an event listener being added. That's like a technical component monitoring what's happening in the browser, whether a user has changed his choice, maybe to stop giving consent for behavioral advertising. So in terms of where I see where things are heading, there are no specific startups that I can name, but I do see a tendency to move away from the open real-time bidding system to a more closed environment, where it's also important to propagate more information about the data in order to assess a lawfulness at the data layer. So not when we talk about accountability as a privacy impact assessment exercise, but really to retain that data already within the real-time bid and within the metadata that's being propagated throughout all the technological specialized companies in the different advertising systems.
One challenge I see for the sort of restrictions on precise location is local advertisers who only, an actual local merchant who only has one, location perhaps, or several locations, and obviously doesn't want to advertise citywide or, much more broadly, and where and when it's feasible to them. Or politicians, the biggest users of targeted advertising, as we have seen from complaints in Europe and frankly extreme uses in the US and elsewhere, who very often want to reach only people in their particular district and who are targeting in that manner. So exactly how to provide some utility. Maybe it's restricting sensitive locations, and again, the granularity, maybe it's not exactly where you are at the moment. Lots of, I think, small steps that might be compelling, put you in a cohort where it's not exactly your location, it's a group of others, but it's relevant enough that it makes an ad buy a little bit more informed, even though it might not be a guarantee that you individually were in that location. A lot of interesting techniques and I think privacy enhancing technologies that are not a magic bullet, but that can help make your case after you put these other limitations. All right, last topic that we want to talk about, the big one. Meta, of course, has talked about going to a subscription, and the subscription is not for free or tracking, it's free or no advertising slash no tracking. And of course, exactly how much of the value of that price is for those annoying ads, which many people might like to be free of, or the tracking, which clearly we see the strong desire to be free of, and how to sort of unpack those two to see whether it's a fair balance. But the decision didn't really, it read, at least I saw lots of coverage and debate, that there was a strong position being taken against a subscription service. What did we actually learn from this decision or the EDPB sort of follow up? Clearly this is an issue that seems to be debatable. I see different decisions in different jurisdictions. Austria said that the model is fundamentally permissible, that paying for access to a website can be an alternative to consent, but it can't be at a completely unrealistically high price. The Danish have said companies have wide discretion when assessing and determining the specific amount that would be a payment as an alternative to consent. What did we learn from these actions on that hot, important topic?
Interesting. So important to note here is that the EDPB, for example, has not taken a position on this. So we don't actually have a decision clearly from the EDPB, nor have we taken a legally binding decision on this issue. So it's still very much being discussed. And actually, there's an ongoing compliance process, which is led by the Irish DPC regarding this, because Meta is still under an obligation to find a legal basis if they want to continue doing what they're doing. They have proposed consent. And so we have this process. What's a bit surprising to me, perhaps, is that even though that process is ongoing and we're having quite a few discussions, suddenly Meta just announced, oh, we're going to push ahead, even though we're still, I thought, discussing some of the concerns. So, for example, one concern is then, and now speaking as the Norwegian DPA specifically, if you're given a choice between a free service with ads or a subscription service without ads, have you then given an unambiguous consent to behavioral advertising? Because that is not what you're being asked to consent to. They ask whether you want ads or no ads, which is a different question. Is that specific? And then you have the whole pay or okay discussion. And we have a quite strong position on this. As a Norwegian DPA, we don't think that it's necessarily always legal or always illegal. Again, it's a case-by-case assessment, and you need to assess, in this particular circumstance or under these circumstances, having regard to the market, is there any players here with dominant positions? Having regard to, the power balance or imbalance between the user and the platform, any dependencies, etc. Is the user in a position to freely choose? I mean, let's say you want to download a currency converter and you have a choice between, many different apps, probably, hundreds. Some of them are free, some of them are paid, some with ads, some without ads. In that context, I think you could probably have a multitude of, different alternatives, and you would still be free to choose between a number of providers. So there aren't really dependencies. And even if it was pay or okay for some of them, it's a free market and you can choose. If you look at the market for social media services and for Meta specifically, I'm not sure if you could really ask a user which has been on Facebook for perhaps 15 years, who have invested their entire digital social life there, we're going to kick you off the platform and remove your digital social life unless you either sign away your privacy rights, which you thought you had under the law, or pay us for you, all of your accounts, including your children's accounts, your whole family accounts, etc., regardless of whether, you can afford that. Is that really a free choice in this specific case? So I think it's not just about whether this is feasible generally. I think is this feasible applied to this specific use case in this specific market? So I think it's complex. It's complex, I would say.
Rob, I'm going to give you the last word. I'll suggest that a couple of years ago, I think it was quite clear that, Facebook is where you needed to be to interact in this digital world. The market has changed quite substantially between the TikToks and between the much broader use of other meta services like the WhatsApps and so forth. My kids, they still have their Facebook accounts, but they cringe if I try to contact them on it. It's not their future anymore, and so the market might be evolving a little bit. And of course, the interoperability requirements of GDPR and the platform rules under the data strategy, in theory, may make it easier to take your digital history with you. But quite fair points. Rob, we'll give you the final take. What else do you think people should be aware of when it comes to these decisions or some of the evolving next steps?
Well, historically, and I've been part of this debate for at least 10 years, the consent discussion has been owned by the DPAs. But with the Bundeskartellamt ruling quite recently, we saw that it's valid for a consumer authority also to use, or that's like for the competition authority to use GDPR arguments, but they would have to consult with the DPA. So I see a slow shift outside of the GDPR framework in answering that question, because obviously there are consumer questions to be answered, but also competition questions to be answered. We see this, for instance, play out with the deprecation of the third-party cookie. That whole change to the next future of digital advertising is owned by the Competitions and Markets Authority in the UK at the moment. They're driving this change. Obviously, the DPAs are bound by the scope. They have to enforce the privacy law, DPA, and in some countries in Europe, the competency for competitions and for consumer laws are not with the DPA, so that adds to the complexity. But I do hear Tobias very well. I've looked through the lens of GDPR, whether it's free, the free choice, whether any alternatives, and the ambiguity of that question do weigh in. But I also see that in answering that question, it cannot solely be answered by the DPAs only. I think ultimately will be in the hands of the European Court of Justice.
It's clear that the issue for the future, which is talked about but not well enough explored, is the interaction between the now strong authorities of the DPAs and prosecutors, consumer protection authorities. In the US, of course, the consumer authority at the federal level is our lead consumer protection authority. But go talk to the Department of Justice, who prosecute very serious privacy infractions, the kind that you get arrested and put in jail for because they've got fraud involved, or child endangerment material, or where they might be collaborating with the FTC. The FTC, of course, here has competition authority, and it shares it with DOJ. As AI becomes a separate regulatory path, we obviously see the complicated interactions that are going to exist in Europe, and increasingly, I was at the White House for the Biden signing of the executive order, and I thought I would look around and know everybody, because it would be AI type policy people and data protection people. Every government agency was there, every think tank, every private sector, because they all see AI as enormously central. And so how competition, how consumer protection, since data protection has such a wide scope and necessarily interacts with every other one of these authorities when personal data is involved. Yes, today we have cooperation, but it's going to make life more interesting and more challenging. I'm grateful that we had Tobias Judin from the Norwegian Data Protection Authority join us to help shed some light on these important decisions. I guess the next step, there'll probably be court continued. We still expect the Irish conclusion. Meta, I guess, has appeal or has the right to challenge the EDPB decision. So I guess we'll still see this playing out. Does Meta have the right to challenge the EDPB decision process-wise?
So So as of now, it seems like they do not, because the EDPB decision is actually aimed at the Irish Supervisory Authority, and the General Court in Europe has said, no, they cannot challenge it directly, but the General Court's decision has been appealed. So live and learn. Let's see.
We are living and learning. Thank you all who joined us, and have a great weekend. All hope we shared a little bit of, at least stirred up some of the issues for further discussion. Much appreciated.
Jules, before we close, let me also call attention for the training that is coming up on the automated decision making. We'll, Christina and Miklekaki and I will unpack the legal aspects of Article 22 GDPR with many recent examples, including the fraud detection by the Dutch Employment Insurance Agency. And obviously we'll reserve enough time for answers and questions. So please visit fpf.org/training.
Thanks very much. Thanks for that reminder. Bye, everybody.
Thank
Have
you.
a good weekend.